5 seconds to go. Start. This appeal is directed against the judgment and order dated 19th August 2016 in Criminal Appeal number 100J of 2013, whereby the Guwahati High Court dismissed the appeal against the judgment and order dated 18th July 2013 and 25th July 2013 as passed by the Court of Sessions Golpara in Sessions Case number 96 of 2012, whereby the appellant was held guilty of the offence under Section 302 of the Indian Penal Code 1860 and was awarded the punishment of imprisonment for life and fine of rupees 5,000 with default stipulations. Before dealing with the matter in necessary details, we may draw a brief outline to indicate the contours of the forthcoming discussion. The prosecution case, based on circumstantial evidence, has been that the victim, being the 20-year-old wife of appellant, died on 22nd October 2010 while residing with the appellant, and that her dead body was brought to the police station by her grandfather PW1 Muhammad Akbar Ali, who made an Ejahar Exhibit 1 that ever since marriage the deceased was subjected to physical and mental torture by the appellant, who caused her death by inflicting grievous injuries, and his family members were involved in the conspiracy. As per the report Exhibit 2, in the inquest carried out at the police station in the presence of informant and other witnesses, injuries were noticed around the eyes, cheeks, and neck of the deceased. The first information report was registered for offences pertaining to sections 498A, 302, and 120B IPC on the Ejahar so made by PW1, and the dead body was sent for post-mortem examination. As per the post-mortem report Exhibit 4, the dead body carried several injuries and the cause of death had been asphyxia due to throttling. It has been the case of prosecution that the appellant was absconding after the incident and was arrested 2 days later at a distant place. After investigation, the charge sheet was filed against the appellant for the offence punishable under section 302 IPC, whereas the other accused persons were let off for want of positive evidence. One of the peculiar features of the case had been that the private witnesses PW1 to PW6 did not support the prosecution, and they essentially suggested that the victim was suffering from illness and died in hospital where she was taken for treatment. The appellant himself, in his statement under section 313 of the Code of Criminal Procedure 1973, endorsed the statements so made by PW1 to PW6 and maintained that his wife died in the hospital. He also stated that he had gone to bring medicines for himself due to illness and was arrested by the police at Bora. The trial court disbelieved the story put forward by the private witnesses and by the appellant about demise of the victim in hospital, particularly with reference to the inquest report drawn at the police station duly signed by PW1 to PW4, and also with reference to the other circumstances as established in the testimony of the investigating officer. Stop.